I am Dale Ratliff with a law firm in Denver, Lewis, Bess, Williams, and Weese, and fully aware that I am the last person standing between you guys and getting on the road, so I will try to keep this brief and interesting. And we're talking about pooling, so how could it not be interesting? All right, so yeah, I am. My presentation's focused on pooling, which, for those in the room, the deal with this, know it's kind of a, kind of obscure and nuanced area of oil and gas law, but it's recently been pulled back into the limelight, in particular because of a federal district court challenge to Colorado's statutory pooling statute. By the Wildgrass Oil and Gas Committee, first Colorado Oil and Gas Conservation Commission. So you'll hear me kind of refer to that as the Wildgrass case throughout that. I'm going to give a brief background on pooling and statutory pooling, an overview of the current challenge to Colorado's pooling statute and kind of the issues at play there, and then provide a brief update on Senate Bill 181 because nobody's done that yet. Okay, so Colorado's pooling statute. Pooling, and again, this might be background for everybody, but pooling kind of encompasses two related and sometimes competing concepts, and that's the state's authority to establish drilling and spacing units, and then the rights of the individual mineral owners within those units. So up here in Colorado's pooling statute, these two provisions encompass those two concepts. The first one provides the commission with the authority in order to prevent waste, avoid the drilling of unnecessary wells, and protect correlative rights to establish one or more drilling units of specified size and shape covering a pool. And then the pooling provision allows the commission to pool separately owned mineral interests for the efficient development of that unit. And so, why do we have forced pooling? And really, this slide should say, why do we have spacing and why do we have pooling, period. I touched on this in the previous slide, but we have spacing and pooling in order to promote the prevention of waste, in other words, efficient reservoir production, and the protection of the correlative rights of mineral owners. And in this manner, pooling statutes, what they really do is they're intended to serve as a statutory overlay to prevent against the consequences of the common law rule of capture, which, as many in this room know, under the common law would just say, well, I drill a well and my well happens to drain your minerals, my straw drinks your milkshake, well then, tough for you. That's how it goes. But that can create waste through, reservoir pressure, and obviously it has consequences for correlative mineral rights owners. So we have pooling and spacing units. And so what is statutory pooling or forced pooling? What that is it allows an operator in the state to pool a non-consenting mineral owner into an established drilling unit. And here's the specific provision in Colorado's pooling statute that allows for that. And why do we allow this? Well, for the reasons we just discussed. Prevent waste, protect correlative rights. But more importantly, people might say, what is this weird picture of a bunch of cars in a field doing up here? And I actually just learned about this, and it's timely. This is the parking lot at Augusta National Golf Club, and this is new to me, but I looked it up, and I guess what happened is Augusta National, home of the Masters, wanted to expand its parking lot, and so it went about buying up all the property surrounding Augusta National Golf Club, and it bought all the property except for one lone homeowner. And that homeowner is in this picture surrounded by what is now a parking lot. And in the Wildgrass case, the most recent hearing on that, Judge Brooke Jackson from the federal court, Colorado District Court, who's an interesting jurist, he brought this story up as an analogy to forced pooling. And his ultimate question was, so at what point do we allow one non-consenting owner to prohibit the development of a unit? And it is honestly an interesting and apt analogy. We'll talk a little bit later. I'll talk a little bit later about, the number one and about how many mineral owners we might allow to prohibit it. But it does raise this notion because it suggests, one, we have an interest in developing units efficiently, and two, and I know that this infringes on personal rights and stuff, we sometimes have an interest in protecting people, maybe even against themselves, because nobody wants to be surrounded by a parking lot and nobody wants to have their minerals drained without compensation. So anyway, I found it to be an interesting story and looked it up. But back to the nuts and bolts. How does statutory pooling work? The statutory pooling statute provision and the commission's rules, and this is prior to the 181 revisions that we'll talk about, really had four main components. The non-consenting owner must receive a reasonable offer to lease or participate no less than 90 days prior to the involuntary pooling hearing. The offer must be upon terms no less favorable than those prevailing in the area at the time the application is made. The pooling order shall be made after notice and hearing and shall be upon terms that are just and reasonable. And the commission may also consider and include within the order such other lease terms as may be relevant. But what you can see from this is that this, like so many other things, is full of terms that speak of discretion, objectiveness, ambiguity. So for example, what are just and reasonable lease terms? And as we'll discuss, this phrase actually plays a key role in one of the challenges in the Wildgrass case. But first, is the rule of capture still relevant? This is a fox hunting thing, because as you may remember or recall or know, that was how one of the ways that minerals were discussed as the common law rule of capture developed as wild animals, subject to capture. But we've had two recent court cases in major oil and gas production states that have called into question and have actually endorsed the theory that the rule of capture does not apply to non-transient minerals like those found in shale plays. These were not in the pooling context. The Texas Supreme Court one dealt with an offset provision in a lease. The operator had adjoining leases from separate mineral owners. The lease said that if they drilled a producing well on one lease, they had to drill an offset well on the adjoining lease that tapped into the same pool. They did so, but the lease owners challenged that and said that actually the well was too far, spaced too far from the other producing well it was intended to offset. The lease didn't have that kind of distance language in it, but the Texas Court of Appeals, State Court of Appeals, upheld that argument, and it did so based on the commonly understood meaning of what an offset provision is intended to do, to prevent against drainage. The Texas Supreme Court reversed, and it said basically, no, we need to look at the plain terms of the lease language, which did not have this distance requirement, and two, we need to think about those terms in the context in which they were developed. And in this context, that was for a shale play, and then it cited to some new authority on this and said those are non-fugitive minerals and the rule of capture is irrelevant to our analysis. And then in the Pennsylvania court case, that was about subsurface trespass. So really interesting case if anybody is history nerd on things like the rule of capture. And they went through the history of the rule of capture and the common law development of the common law principle that the rule of capture prevents an operator from a subsurface trespass claim for the reasons we discussed. If I drill a well and my straw drinks your milkshake, that's just how it goes. They're fugitive minerals, and the rule of capture prevents me from a claim of trespass against you. But the Pennsylvania Supreme Court said, not so fast in this instance. And again, looked to some scholarship that's out there and endorsed this holding that hydraulic fracturing is distinguishable from conventional methods of oil and gas extraction. And unlike oil and gas originating in a common reservoir, natural gas when trapped in a shale formation is non-migratory in nature. And thus, given this distinction, the court held that the rule of capture would not protect an operator from a claim of trespass if a subsurface fracture crosses a boundary line and causes the results in the extraction of gas from an adjoining lease. There weren't facts in that case to suggest that's what happened. Got remanded for further evidentiary hearing, but it was a very prominent legal holding on this. And so that notion about whether the rule of capture is still relevant underlies two of the challenges that are currently happening in the Wildgrass case. The one is a claim that the COGCC just simply does not have jurisdiction to apply the statutory pooling to non-transient minerals in a shale play or hydraulic fracturing. In other words, it's just they're acting ultra vires should they do so. In the most recent hearing on the matter, the commission declined to address that issue because they said it wasn't well enough developed in the material submitted. And then two, we'll talk about this one at the end, it underlies a claim that application of statutory pooling to non-fugitive minerals, non-transient minerals, would violate substantive due process because there's no longer a legitimate state interest at play because the rule of capture and drainage are not relevant to the inquiry. So we'll talk about that here a little bit at the end, but we'll get to the other main issue that's going on here, and this is, and what about the environment? And the question is, I put up earlier, kind of four of the main major things that happen in statutory pooling with Commission Rule 530 and the statute factors, and the environment's not expressly mentioned in any of those. But what's being challenged is, do the terms just and reasonable require the commission to consider environmental health safety effects in a pooling hearing? And what is the role of a consideration of environmental health safety in a pooling? In a very recent District of Idaho case, again, federal district court, this claim was raised, and it's not directly explicit, but basically what happened was the court said, looking at Idaho's pooling statute, which contains the same just and reasonable language as ours, it said, well, just and reasonable may include environmental considerations. And basically, Idaho Department of Lands, you did not adequately explain why you excluded evidence on potential groundwater contamination and noise pollution. The Idaho Department of Lands had just said in their order, these are outside the scope of the statute, these are outside the scope of our jurisdiction, and the court said, well, I don't know, just and reasonable seems pretty broad, and basically you haven't told me specifically enough why those don't include these considerations. Relying on that case, in the February hearing on the Wildgrass case, Judge Jackson, basically what he did was he first ordered the commission to no longer delay the hearing on the pooling order. So he said, you're going to have the hearing that's scheduled for March 12th, 11th and 12th. And two, he said, while this court does not set the agenda for the commission's hearings, the court hopes that the commission will elect to consider the environmental health and safety issues concerning the proposed drilling. So what did the commission do? Well, the commission had its hearing on the 11th and 12th, and it allowed Wildgrass to submit evidence about environmental health and safety concerns. And then in its order, it said neither Section 116 or Rule 530 require the Commission to consider in a statutory pooling proceeding project economics, the financial viability of the applicant, or concerns related to public health, safety, and welfare, and the environment. But we did it because the judge told us to. And first point on that is that's good advice. If a federal judge tells you to do something, do it. Second point on that, though, is that the Commission, there's a valid argument that the Commission has a point here and has a position. And that's because what is getting lost in this discussion at times, and that some in the room likely know that go through this process, is that prior to a pooling application and hearing, there's a comprehensive evaluation of environmental, health, and safety considerations as part of the process to approve the APD, the application for permit to drill, your Form 2, and as part of your site location assessment, the Form 2A application. So, for example, in the Wildgrass case, the project that was at issue went through that process. Both those need to be approved before you can submit your pooling application. And that resulted in a public comment period that lasted just over a month. There were 300 comment letters submitted and 166 unique comments on environmental health and safety factors, the specific drilling permit terms, and the BMPs included in the permit. So at least one commissioner remarked in the transcript that the order to consider environmental health and safety considerations at the pooling stage felt like a collateral attack on the permit approvals that had already happened. And in addition, I just wanted to mention, in addition to that public comment period, Rule 503, Commission Rule 503 also allows certain entities to request a public hearing on the Form 2 and Form 2As, and that would include local governments. So, back to the very fun stuff, the Constitution. Things always get more fun when the Constitution's involved. So what does the Constitution have to do with this? Well, there are a few constitutional claims in Wildgrass's complaint, and the two that I find most interesting implicate the Due Process Clause. Quick con law background for those that missed this episode of Schoolhouse Rock. The Due Process Clause of the 5th and 14th Amendment has two components, procedural and substantive. Both basically the procedural deals with, well, what procedures does the government have to afford you if it's going to infringe on one of your rights? And substantive says if the government passes a law that infringes on one of your rights, is that law related to a state interest? The strictness of the test is related to the right at issue. The right at issue here is property. So the two questions are, one, I alluded to this earlier, but it's, do the Commission's procedures to protect owners' rights to just and reasonable terms satisfy due process? That is what was at issue in the District of Idaho case. And like I said, that's where the court said, well, we can't have a full ruling on here because you haven't really told us why. It doesn't include environmental considerations, and we obviously have that same language here. And then the second question relates back to the rule of capture discussion we had. And that is, if the rule of capture is no longer at play, and we have a statute that infringes, and by infringe I mean limits your right, and it's your property right, and that's what statutory pooling does in a way, because it says you own this mineral right, but in certain instances we can make you do something with it. So it's a right that, it's a law that touches your property right. Well, the test is it rationally related to a legitimate state interest? And the argument being made is, if you take away the rule of capture, the things it was intended to, and what pooling is intended to prevent, protection of correlative rights, and efficient development of the resource, if that's no longer at play, what's the state interest? This hasn't been fully vetted in the briefing. This is just off the cuff, Dale, non-professional opinions, but I think that some of the things we'll see are that, well, it still promotes efficient development, regardless of the rule of capture. And also, what about minimizing impacts, surface impacts, consolidating development, the other reasons why we have units, spacing, et cetera. So definitely a space to be watched and interesting if this case moves forward. Then finally, everybody's favorite topic for the last 2 days, Senate Bill 181. So Senate Bill 181 touched the pooling statute, and it made a couple of revisions. One, an applicant for a spacing order must now first file an application with the relevant local government if that local government has chosen to exercise its jurisdiction over the siting of oil and gas. Two, and I know this has already been brought up, but an applicant, and this goes to the Augusta National example, are we going to allow one homeowner or two? Well, the General Assembly has now said, nah, we won't let one owner or two or three prevent development, but we might allow 55% of them to do so because they've included now for the first time a threshold limitation on the amount of leases you need to have prior, and it's more than 45% of the mineral interest to be pooled. And then they changed the definitions of waste and abuse of correlative rights so that it does not include the non-production of oil from a formation if necessary to protect public health, safety, or the environment. And again, what this is going to do, people have been calling it the unknown bucket, or at least I heard that term one. I'd like to chunk this into the unknown bucket of how this exactly plays out. But what it does is it relates to, again, to this rule of capture type issue, and it suggests at least that there's a notion that by changing this, it then again undermines what is the state's interest in pooling and spacing units and then in forced pooling. But the primary point that I want to make on the SB 181 that I found most interesting is following the March commission hearing on the wildgrass pooling order, there was a status report hearing in front of Judge Jackson again that I went to watch. And he raised 181. It wasn't final yet then, and he raised it and he said, you know, I want you guys, both parties, I want to know more about what's going on in 181. And his point was this. Basically, the General Assembly has the bill open as we speak, is what he said. And so we're all here arguing, and why should I weigh in if the legislature is literally working on this as we speak? And so now we have a final bill, and we have some tweaks to the statutory pooling and to the pooling statute. And I think, personally, again, non-professional in my own opinion, that in the current challenge, subsequent challenge, it's potentially significant that the General Assembly went into the statute while these challenges were pending. We assume they're aware of current developments in the law, and it made changes and significant changes to the statute, but then it also more or less left it intact, which potentially suggests an intent, you know, not to do away with it as we know and address these environmental health issues or the constitutional ones. So that's it. Like I said, I try to get you guys going and out of here. And so any questions?